Make to the Lordship. Lordship, with the consent of the other side, I beg to mention item numbers 2 to 6, Lordship.
2 to 6.
Lordship, it may be posted after 2 weeks, Lordship. In the meantime, we shall file our affidavit.
Item number.
See. Yeah, that's it. In fact, you are supposed to take steps for service upon the private respondent.
Fine.
You have not taken any in this item number 2.
Dasarath Adhikari.
Dasarath Adhikari.
Lordship, I am there.
Hmm.
Lordship, we have taken steps, but they were supposed to file affidavit.
What about me? You have not taken the steps.
As
This is
per
what
the
they
last
reported
order.
by the registry.
We will take again.
Lordship.
Okay. Affidavit has not been filed on behalf of the state as well as the Union of India. And the appellant in writ appeal number 297/2018 has not taken any steps for issuing for service of notice upon the private respondent. 2 weeks time is granted to the parties to do the needful. Just after 2 weeks.
Obliged.
Obliged.
Item number 8 to 16. From 70 to 30.
May I please, Lordship? Lordship, I beg to mention item number 20. Consider the other side. Lordship, matter may adjourn for the 2 weeks. 20 minutes.
2-0.
Yes, my lord.
Why you are seeking time?
Lordship, my senior is not well, my lord.
But earlier the court has granted you 3 months time and so far as I remember, one more litigation came before this court in relation to these parties only.
Yes, madam. This has been, they have been mentioning it many times, madam.
Earlier also,
Yes.
so one matter, a separate matter from this appeal
Yes, madam.
that
Yes.
appeared, that came up before this court.
Yes, they had withdrawn that, madam.
They have withdrawn that matter. Yes,
Same issue, madam.
same issue.
So read appeal
There's nothing
15.
with this matter. You are unnecessarily lingering on. Yes, what do you want to say now?
My lord, my senior is not well. He is not even in the court, my lord.
12 or 24.
Pass over for the day. Pass over for the
Okay.
day.
Obviously, my lord.
May I please, Lordship? I beg to mention item number 30, Lordship.
3-0.
30. For the day.
Consistent with protective regulation act is under 70. 50.
Why you are seeking time?
Lordship, both of my seniors are out of station, Lordship, both are.
That age of 50 years and that.
Lordship, for kindly 1 day, Lordship, for today, Lordship.
After a week.
May I praise your lordship? If lordship by agreement, what will be completed? One case, one. May I praise your lordship?
Yes.
Lordship, I beg to mention item number 23. Your lordship, your lordship may not like to take up this matter.
Now, before another bench. None of it us.
Obliged, lordship.
Yes.
I beg to mention item number 24, 25 and 26, Lordship. Adjourn for the day, Lordship.
4, 25,
And 26.
26.
My-
In this matter,
My senior is not available today, Lordship.
nothing knowing, how can you ask for continuance after the duration as nothing in this item number 24?
Nothing is,
Nothing. in-
Only for the day, Lordship.
it's already becoming gone.
Pass over for the day.
Lordship. I'm obliged.
May I please, my lordship?
This item number 24, 25, 26. In all these matters you are asking.
Yes, Lordship.
25 also same thing, sir. 26, the notification has already been issued. If they have a problem, they'll have to do it. Arbitrary.
All these matters pass over for the day.
Lordship.
24, 25 and 26.
I'm obliged.
May I please, my lordship?
Yes,
I beg to mention item number 29. As my senior counsel is out of Guwahati.
all the senior counsel, they one where. Everybody is making this mention senior counsel. They're having some party or what? Then
Lordship, can this matter be fixed after 2 weeks?
Yes. Applied a provision of prospect.
adjourn.
Thank you.
Wait, Lordship. I beg to mention item 37, Lordship. Matter became
27,
infectious, Lordship.
37.
37.
Yeah.
37.
Infectious.
This has become infectious.
He has been given.
Infectious.
Settlement has been made.
You mean to say infectious?
Infectious, Lordship.
Dismiss the infectious.
There is an I.
Yes.
I.
I also dispose of. Yes.
May it please
Like-
your lordship, item number 30 adjourn for the day lordship. My senior is not available today lordship. 3-2,
3-0 is also.
3-2.
3-2.
3-2. But then
Much of
you are supposed to some information to supply some information.
some reply lordship.
Get me the pen. Who is for the petitioner?
Lordship,
You are for the. In last occasion, we expressed their opinion that you have failed to persuade us to hold that this rule 28(3) of the rules of 2018 is ultra-virus to the constitution and use short time, sometime.
lordship only for today lordship. He is not available.
Learning concept of the petitioner face a week's time to satisfy this court about the query raised by this court wide order dated 23rd of February 2024.
Much of
May I please, Lordship? Lordship, I beg to mention item number 8, Lordship. Yeah, Lordship, actually, in this case, Lordship, we have to withdraw this matter because Lordship, matters relates to promotional benefit, Lordship, but
Well,
you already retired, Lordship.
Item number 8,
8.
no steps for issuance of notice to the respondent has been received. They have not taken
Lordship, I have to withdraw, Lordship, now.
another bench.
You want to withdraw?
Yes, Lordship, I want to withdraw. If Lordship permits, then Lordship, because she already retired, Lordship.
Withdraw the corrupt.
Wants to withdraw, dismiss this withdrawn.
Withdraw.
Lordship. Obliged, Lordship.
Because I documentation item number 41, the hearing matter.
40.
41.
Oh, one.
Well, my
Yes.
senior is out of station due to medical issues, my lord. Can it be postponed for 2 weeks, my lord?
Subject to the convenience of the lordship, in the first week of June, if it may be fixed.
But then 8 weeks.
Oh, no.
May it please, your lordship. And I pray, my lord, listing of a matter on Wednesday, filed it on Saturday,
Item number,
not item, my lord, it's a new motion.
you want to get it listed?
Yes, on, Tuesday, Wednesday. We have filed it on Saturday, there is urgency.
Yes.
Apply.
May I please, your lordship? I beg to mention item 36, lordship. 2 weeks time, I need to file another one affidavit, lordship, in that case.
The patient that cannot be killed, but the group was done. Even
No, still the grievance of the petitioners,
Yes, lordship. Yes, lordship.
means the government has produced some, documents that they are providing ration to these people.
The lordship, because not only for these people, it's PIL is for the marginalized section of the society. We are paying for.
Only you, you filed this PIL during during COVID period.
Yes, lordship.
These people were starved and, since they are not having ration cards,
Yes,
therefore
lordship.
some assistance be provided to them.
Yes, lordship.
And there are orders of the government where they are providing you the assistance. What remains now? It's
Ration cards were not being issued, lordship.
So have you filed any,
Because I-
response to the,
Yes, yes.
filed by,
I had filed one on 10/1 also. I had filed one. I need to file another one.
why?
So- Another one reply, lordship. So I need to file one additional affidavit. Respondent number 2, lordship, with that regard. They have filed their affidavit. So I want to file one rejoinder to respondent, to reply to respondent number 2, what they have filed, lordship.
I'm concept of the plan place some more time to file counter to the affidavit, counter to the reply filed on behalf of the respondent number 2. Just after 6 weeks. Yes.
Deeply obliged, lordship.
Main point already.
Yes.
May I pray, my lord? My lord, I pray before lordships for listing of the matter, my lord, IA, my lord. This is regarding consideration of promotion, my lord. And my lord, since in the IA, it was listed on 2nd of May, my lord. And there was just some small mistake, my lord, on the cause title of respondent number 1.
So what we have done on the 2nd of May.
Yes, it was listed. And
Then
now,
what happened?
now I would like to mention, my lord, for listing on 8th and on 10th of May, my lord.
2nd of May, what order was passed by this court?
On 2nd of May, that could not be passed, the order could not be passed because there is some mistake, my lord, in the IA.
We have given you the time to cure the mistake or what
Yes,
we have done?
yes, already I have filed this IA, my lord. So
We might have fixed any date in that matter.
no, this IA has not been, this no order has been passed, my lord, in the IA.
Next week,
On,
next week,
Lord.
yes.
May I please? My lord, I am praying for listing this matter for withdrawal, my lord, for not this day.
Before
For
Withdrawal.
withdrawal, my lord.
withdrawing, what's the urgency in that withdrawing? Withdraw at any point of time when it is listed.
The matter may be listed on Wednesday. my lord. Bless you.
Daily list for orders, item 1.
May I please, lordship, in this case, steps could not be taken because the person had been transferred elsewhere. I filed the amended cost title, lordship will permit me to take steps in the new address.
Concept of the petitioner has submitted that amended cost title with the fresh address of the unserved respondent as being filed, office to take the same on record.
It's already on record. Same application. Yeah, well, okay. Starting on.
That's really put on record, no? It's not taken on record. It's supposed to.
They have sent.
It is to be taken on record.
Yes,
Amended
Lordship.
cost title.
Yes, Lordship.
Submitted an amendment cost which is kept in record, kept on recording. Same data, that is the.
Then we should be not.
One fifty times this company is making for. He's an employee. He doesn't make him- he doesn't make a service to the field.
Amended cost title already filed. Amended cost title filed on behalf of the council for the petitioners is taken on record. Let notice be issued to the sole respondent on the fresh address. The notice upon the respondent be served through Military Engineer Services Headquarter Commander, Work Engineer. You make the mention at this address. So and so within a period of 2 weeks. That's the.
I'm so obliged. Lordship.
Item 7.
May I please, Your Lordship?
We are not taking-
I may be allowed to take steps up to respondent number 4. As per cause list, my lord, 5, 6 and 7, 8.
Lordship, I am
Okay.
entering appearance on behalf of 5, 6, 7, and 8.
What about respondent number 4?
4 not. I am only for 5, 6, 7, and 8.
Okay. As per the office note, no fresh steps for issuance of notice upon the respondent number 4 to 8 has been received. Full stop. Mr. So and so put in appearance on behalf of the respondent number 5 to 8. Let fresh steps be taken for survey,
Respondent 4.
for service upon the respondent number 4. Requisition be filed within a period of 1 week through registered AD as well as Dasti.
Deep level.
Item number 9.
May I please, Your Lord. Lordship, in response to the order passed by this honorable court, I have taken steps for service of notice upon private respondent number 5, my lord.
Yes, you are. appearing.
I am appearing, my lord.
You are appearing. देखिए, Mr. So and so put in appearance on behalf of the respondent number 5. Service is therefore complete. List this writ appeal for admission after 2 weeks.
Obliged.
Item number 10.
Respondent number 12 and 13. Service upon the respondent number 12 and 13 is not affected.
Not completed.
Is not affected. When the notices are issued.
This is issued on
Already.
the notices 28, 4, 28, 3, 2024.
3, 4, 24. Fresh steps. Notices upon the respondent number
Well,
1, 12 and 13 or only 12 and 13.
My lord, I am appearing for 1, my lord.
one.
You are appearing for.
Yes.
Notices upon the respondent number 12 and 13 has not been received, either served or unserved. To stop, consider the applicant is directed to take steps for, take special steps for service upon the respondent number 12 and 13 within a period of, you take fresh steps for service of notice upon the respondent number 12 and 13 within a period of 1 week on furnishing these steps. Let notices be issued to the respondent number 12 and 13. Registered AD and the.
One to happen is skeptical.
Yes.
No, one he has appeared.
Already has appeared, we have already marked 12 and 13.
Item 11.
Yeah, so service on 1 and 13 waiting, sir. Notices issued on 30.
Oh, in this matter, I am appealing for respond number 1.
You are
2 weeks
appealing.
time is required to file objection against this delay.
What about respondent number 2 and 3?
Who I think
Who has
someone
appeared, sir?
filed it for now.
Steps who has appeared, 3.
Who represents Mal, the name is Son Mal.
2 is appeared, sir. Appeared, sir. It's here.
Who is the respondent number 3?
3 is not appeared.
3 is the person who was also required to be provincialized, madam.
Okay.
File the
Notice of the IE have been served upon the respondent number 1 and 2. Mr. So and so put in appearance on behalf of the respondent number 1. None is appearing on behalf of the respondent number 2.
No, 3.
Uh,
Notice, sir. Today, nobody. No, there is an advocate who has been in
the respondent number 1. Service of notice upon the respondent number 1 and 2 has already been effected. Mr. 1 is, Mr. So and so is appearing on behalf of the respondent number 1, whereas Mr. So and so has filed wakalatnama on behalf of respondent number 2. Notice upon the respondent number 3 has not been served. Await return of notice upon the respondent number 3 for 3 more weeks.
Obligement.
Item 12.
Compassionate appointment. Compassionate. There is a delay in filing.
Delay is of 288 days, madam. Even after, even if you don't, if it is allowed also, madam, the main case, madam, the delays of 19 years.
Compassionate appointment application.
You are appealing for the respondent.
Respondent bank, madam, yes.
There is a little judgment of the Supreme Court. Even if it is the fault of the person, or of the government in after a long length of time, the concept of immediacy is done. This is not shy. This is not Nagar. Good, sir. Straight, no.
That's the appeal. Yes, Mr. So and so put in appearance on behalf of
Respondents.
all the respondents. Would stop. The present IA is filed on behalf of the applicant with the prayer to condone the delay of 288 days in being connected appeal. Would stop. Having gone through the contents of the application and after hearing the we have gone through the contents of the application and taking into consideration the fact and circumstances of the case, we limit appropriate to allow the IA to stop. Hence, the IA is allowed, delay of 288 days is condoned. Registry is directed to register the connected writ appeal and list it before this court for admission after 2 weeks.
That is a fact. It's a description. 1 year also, maybe 15 years, maybe.
Yes.
Item 13 and 14.
Delay of 29. Sir.
Issue notices returnable on so registered AD this thing.
Item 15.
May it please the Lordship.
Yes.
Lordship, the IA is for inserting of the name of respondent number 5, my lord. Because earlier the respondent number 1 has retired. My lord, paragraph number 6. To insert,
Page 7.
For substituting the.
yes, my lord, for substituting, yes.
For impeding. Continue. Continue. Normal procedure that. You can't do nothing. You can't even implement the product.
So, you do one thing, well, you are this implementing the new respondent as respondent number, you may substitute the respondent number with the new incumbent.
My lord, because as my lord, as per GHC rules, my lord, the respondent number 5, we have to impede him as a new respondent. That's why he can take up the incumbent place.
Since the respondent number 1 is no more in the office,
My
he
lord.
can't implement that order.
My lord.
It is the chief secretary present incumbent, he can implement the order, then why to have this person in the, as a area of respondent?
My lord made, substitute respondent, the
Application. This IA number 2 is preferred on behalf of the applicant to the to impede the impede the new chief secretary as party respondent number 5 in the contempt petition. Stop. It is noticed that the respondent number 1 has superannuated from the post of chief secretary, government of Assam, and in place of him, the Dr. Ravi Kota is appointed as chief secretary. In such circumstances, we deem it appropriate to allow the applicant to substitute respondent number 1 with the present chief secretary, Dr. Ravi Kota. Stop. Amended for title be filed within a period of 1 week. On filing of the same, let notice be issued to the newly substituted respondent number 1, returnable on so and so, IA is disposed of.
my lord, in the contempt, the notice has not been issued till yet, my lord.
Till date,
Yes,
okay, then only, don't do that. This substituted notice issue come. That only. Substituted in place of the amended cost title file. Let IA is disposed of, contempt petition be listed for the listed before this court after 2 weeks.
Much obliged, my lord.
Item 16.
Delay condonation 31 days. Notice have been issued.
Yes.
Fresh.
Yes, my lordship.
What was the ground for delay?
Medical ground, my lordship. Medical ground.
Returnable 6 weeks registered date. And that's the.
Obliged.
Yes.
Item 17.
Notice.
Realized.
6 weeks. Dusty. Registered AD and Dusty.
Dusty, my lord.
Registered AD as well as Dusty both.
Lordship.
For admission, item 18.
There is none. But the only ground of rejection was when she applied. There is a provision. It's 30 clause 2. This requires that along with the application of certificates by the government down what secretary. She had not annexed. Subsequently, she came up with the plea that he have bought land there and thing now. That cannot be. No, so and then that's the only ground where the judge has gone and.
So for the time being, in the second one will become the.
Item 19.
Yeah, please, Your Lordship. So I put a respondent number one. With some difficulty, my lord, just
For loud, please speak loud.
with some difficulty, my lord. Okay, for please do better on Monday, my lord.
What's the difficulty?
I changes some difficulty, my lord.
There's a lot of confidence in them. Commanding always without a check, you have given what more is. It's really. We have not even contested the proving of. We have only gone on the unknowns of the support. It's not confident to the bank employee. Different.
Yes.
I prefer adjournment, my lord.
But taken into consideration, he is a bank employee, he indulged in irregularity. Maybe the bank has not suffered any loss, but ultimately it's a matter of trust. Okay. When concept of the respondent takes some time to prepare the matter. Next time we are not going to adjourn it.
On Monday.
Monday.
Hello. Hello, bless.
Coming Monday.
Item 21.
Same things.
May I please? My lord, in terms of the last order, my lord, certain instructions were sought from the government advocate
What instruction?
to apprise the court, my lord, whether the consideration of the 5% quota was at the time of consideration of the case of the petitioner by the SLC or DLC. Because, my lord, the legal position as to the consideration of 5% quota, my lord, is at the time when the DLC makes the recommendation. And at that time, my lord, there was vacancy.
You don't understand. The repetition was sometime in. Both the grounds. Both the grounds. Delay, basically 8 years. 8
Whatever it may be, since there is a 8 years delay, the learned single judge has rightly not interfered with the order. Ultimately, it's a matter of compassionate appointment.
My lord, in a similar case, my lord, at page 41, my lord, same DLC meeting, my lord,
Yes.
page 41.
Yes.
The case was considered and remanded back to the SLC for fresh consideration, my lord, same department. Page
How much delay was there?
There also, my lord, he died in harness in the year 2013.
Maybe. Yes.
My lord,
The last case when the matter not that one, the other. One. He we had not applied for any particular. They consider her to take trade. Found her not eligible. But then we have not applied. Postponement for the thing to come. Here means only the grade 4. And the other one that was responsible. It was just a discussion of just here. There was a delay of about 4 years including the second committee.
These cases are altogether different. In that case, the situation was already different. In fact, the court has found that one vacancy was there. But at that time, when the SLC took up the matter, the vacancy was not there. But that doesn't mean DLC has taken the matter. At that time, vacancy was there. Here, it is not the case.
No, here my case was considered, my lord.
Yes.
The grounds for rejections were
Why
not valid.
so the court with a great delay? That we are asking.
No, my lord, after approaching, my lord, my case was considered by the DLC, SLC, my lord.
After 4.5 years of the rejection of your case from the SLC, you appeared, you approached this court. And only on this ground, the land single judge not to tell you. We don't find any indignity in that.
Reason given.
Rejection by the SLC
Yes.
My lord, the rejection by the SLC was not communicated to us, my lord.
That is not,
And my lord, the grounds for rejection, my lord,
sir, this is now, you are now taking altogether a new ground.
No.
Here in there, before the learned single judge, you said that since
COVID.
the outbreak of COVID-19, he failed to appear before they approached the court.
my lord.
And now you are saying the SLC decision was not communicated. This was not the
My lord, but the,
ground before the learned single judge.
It is
Not
order
the-
March 2020 and that approached the honorable court on 29/5/2022.
my lord, the issue here is, my lord, whether the rejection by the SLC is, my lord, correct or not, my lord.
Sir, yes, it is wrong.
My lord.
We admit that. Why you approached this court after a delay of 4.5 years? Who
My lord,
prevented you?
my lord,
And
in
it's
fact,
ultimately,
my lord,
it's not a, you can't claim as a matter of
my lord, the
right.
time period which is prescribed, my lord,
It's a exceptional.
it is not followed by the
Major
state
failure
government
by
also, my lord. The
government.
time period which is framed
Your father
for
died in the
consi-
year,
my lord.
2015.
so you have survived without the government job till date.
Not I,
9 years have passed.
not the case, my case is under consideration, my lord. That is,
We are not.
I am pursuing it, my lord. That is why, my lord, I would page, my lord, page 37, if I may
Yes,
point out, my lord.
yes.
In a similar case, my lord, at paragraph 3, page 37,
Yes.
we have taken note that the DLC meeting was held on 21/12/2017, whereas the date of the SLC meeting was 15/9/2021. The requirement of the SLC is to consider the vacancy position as evaluated by the DLC on the date of its meeting, not when the SLC would take up the matter, which in the present case is after 4 years. Here, my lord, when my case was considered by the DLC, my lord, recommended by the DLC to the SLC, there was a vacancy. And the SLC, my lord, sat after, my lord, my lord, 3 years.
No, no, no.
No.
1.5 years.
1.5 years.
SLC to this,
2017 and 2018.
SLC to get your position.
31/12/2018.
Okay. DLC to
DL is 1/3/2018.
Anything else?
18, my lord.
18.
2018, my lord, after 1.5 years, my lord, the SLC sat, my lord.
Not a great case. Delicate. The London single judge has dismissed the petition filed on behalf of the appellant challenging the decision of the state level committee, whereby the application of the petitioner for appointing him on compassionate ground on account of death of his mother has been rejected,
Not being within the 5%.
has been rejected. Full stop. the learned single judge has dismissed the petition solely on the ground that the petitioner has approached, that the appellant has approached this court after a delay of 4.5 years from the date the SLC has rejected the candidature of the petitioner. Stop. And single judge is of the opinion that the scheme for appointment on compassionate ground was floated by the government of Assam so as to give immediate relief to the family members of the deceased employee, which has lost the sole bread earner. Full stop. The landed single judge further observed that the father of the petitioner expired on 19/9/2015, and since then for almost 8 years, the petitioner has survived without a government job. Full stop. Having considered we are of the view that the learned single judge has rightly refused to interfere in the matter on account of delay in approaching the court, as well as on the ground that if the appellant has survived for a long time without a government job, can't be he is not entitled for any equitable relief from this court. Hence, no interference is called for. We will dismiss.
This one is- I don't think so. There was an order from the beginning.
Item 22.
Lordship, I'm online.
Yes.
So if before Lordship it comes up, may I just most humbly make a submission? Lordship, in this case, we have to complete the pleadings, but more importantly, Lordship may come to the impugned order, para 32.
Yes.
It's on page 282, Lordship.
Yes.
So, Lordship, this is actually a batch matter in the APSE cash for scam, which is pending, which is the lead matter is Gitanjali Dole.
What happened
So,
in
Lordship,
Gitanjali Dole?
So, Lordship, last order of Gitanjali Dole was in September. It was to come in November. It hasn't got listed after that. So, I would respectfully say that this matter should come after Gitanjali Dole is decided. So, I'm expecting after the vacations, possibly Gitanjali Dole will get
Take up the matter together.
Lordship, I may respectfully point out that then it may be kept pending.
We are hearing new arguments, my lord.
No, Lordship, respectfully.
I can
know,
appreciate, my lord, the matter is pending before the Honorable Apex Court. We should await outcome. Well, after that, Gitandoli's matter is decided, this matter should be listened. I'm sorry.
Gitanjali writ appeal is already pending.
Yes, yes.
Yes, Lordship, it is pending. And Lordship, there is a slight difference in these facts. So therefore, this would have to be heard last. If it is kept along with Gitanjali Dole, it has to be heard separately at the end of the arguments of Gitanjali Dole or after that.
That you can very well pray at the time of hearing of the appeals.
Yes, of course, Lordship may just note it, if I may respectfully say, so that Lordship at that time it is recorded, we wish to wait.
We'll list it along with that writ appeal.
With my submission that this would be heard after the arguments of Gitanjali Dole, just to distinguish.
At the time when the hearing begins.
As Lordship
At that
pleases.
time you can very well point it out.
Okay, Lordship, as Lordship pleases. And in the meantime, we can complete the pleadings, Lordship. We'll make...
In writ appeal, there is no any scope of any pleadings, my lord.
So, Lordship, we would like to file a reply. We would like to file a
Well, at least as per a High Court rules, my lord, there is no scope of any further affidavit.
Lordship,
In writ appeal, we don't file
Lordship, we've been allowed in other matters. Mr. Chaudhary, my learned friend, always says so. I always make the same request.
We are allowing the persons. They may
We'll be only adding to the volume.
whatever it means.
They cannot bring any new points. State's perspective is already there in the affidavit.
Lordship, this is a mega scam. So we wish
Just
to
a
keep our reply.
My lord, whether it is a mega
Just a
scam or a
message.
minor scam,
So just the impugned judgment is passed by the learned single judge, mainly relying on the decision of a coordinate decision of a learned single judge of this court rendered in Hitali, Dole and others versus State of Assam and others reported in 2020 3 GLT 800. Stop. It is informed that the writ appeal challenging the judgment passed in Gitanjali Dole Supra.
The lead case is writ appeal number 101 of
Is
2020.
pending consideration before this court. In such circumstances, we deem it appropriate to hear this writ appeal along with the writ appeal number.
Number.
101 of
59,
2020.
59 of 2023, Lord.
101 of
2020, my lord.
2020.
Yes. And the series of cases are there.
Yes, Lord.
In the meantime, parties may file the additional pleadings if desires. to.
Lordship has issued notice, my lord, today. Your notice was not
Achha,
issued.
notices have not been issued.
Yes, yes.
Okay, issue notice करके नहीं करते ना, issue notice returnable on so and so. Yes, Mr. Kohli, you are appearing on behalf of?
My lord, there is one aspect, my lord. The main person who have allegedly have received money, as mentioned in the affair, he has been reinstated in service. He's my
No,
lord.
Lordship,
that's
that's an
in accordance with
incorrect
open
submission.
instruction.
Respectfully,
How that
that's
is
an
possible?
incorrect submission. That's an incorrect submission. I would respectfully say.
Whatever the response to it, if the person who was allegedly received money.
Yes, he has been reinstated and his DP has been closed.
They have to answer at the time of.
Exactly.
You are appearing for all the respondents, Mr.
I accept the notice, my lord, for
Yes,
the
Lord.
Mr. Dina, accept notice on behalf of all the respondents. Services.
And I'm appearing in all matters.
Services therefore complete. Then that order we have already passed. No?
I'm obliged, Lordships.
Sir.
Item
Milords,
27.
I appear. Milords, I appear online, Milord, for item number 27.
Item number 27.
Yes, Milord. May I start, Milord? May I start my submission? Milord, can I start, Milord?
Yes.
Yes, Milord. Milord, this petition is filed against the order passed under GST law, Milord,
You have challenged
by the
that,
state tax.
validity of section 16(4) of the GST Act.
Yes, Milord. Not only that, there is also the limitation notification also I have challenged, Milord.
That is, that's only it is, Mr. Payal, some similar matters are already pending.
Yes, sir.
Where
And,
the validity is under challenge.
Lordship, and now matter is pending before Honorable Supreme Court. Lordship.
Here the appeal number, the writ petition number,
Lordship, here,
similar matters.
I think they have annexed one order that is passed by the single judge. And
Division bench.
section 16(4) will also be challenged, that is pending before the Honorable Court. But no stay order has been passed since.
No, there is an action.
There was stay, Milord.
Authorities may not proceed with the proceeding.
WPC 529/24, they're passed by single judge.
No, 103 is a division bench order.
Lordship, that is before the Arunachal bench court.
That is before the division bench of this court.
Yes.
Then
Lordship, here they have challenged two things, Lordship. One, section 16(4), as well as the Sokos notice issued by the state GST, Lordship.
Fine.
And 16(4) on 4 High Court says upheld the validity of 16(4). Now matter is pending before Honorable Supreme Court. And in
but if in the corresponding matter, in the identical matter, some order is passed, we have to follow
yes,
that.
that is there.
Is there? Yes.
And here the notice was issued by the state GST. Lordship.
Yes.
Milord, party is also same, Milord, before Arunachal bench.
Just a minute, please.
Sorry, apologies.
In the concept of the appellant, the petitioner has submitted that this court him a writ petition involving identical issue was pleased to issue notices to the respondents and has also passed interim order. Stop. Lanet, counsel appearing for the, you are appearing for?
Respondent number 3, Lordship.
And what about the others? How many respondents are there?
4 respondents are there.
1, 2, 3, and 4.
For the state GST.
State GST.
Let us record the name of B. Gogoi.
Mr. Gogoi.
This Deputy Commissioner of State Tax.
Yes, sir. I can appeal.
Issue note, the concept of the petitioner has said that writ appeals involving the identical issue has already been entertained by this court, wherein notices have been issued and stay has also been granted. Stop. Issue notice, Mr. So-and-so, जो भी यहाँ से जैसे presence so-and-so put an appearance on behalf of the so-and-so respondents. Services therefore complete. The counsel for the respondents may file their response to their petition within a period of 4 weeks. In the meantime, it is ordered that the authorities may proceed with the proceedings initiated pursuant to the impugned show cause notice. However, no final order shall be passed till next date.
Milord may say, Milord, that here in this case, order was already passed, Milord. So order may.
Then we are not going to interfere, sir. Already
No,
passed,
Milord.
we are not going to pass interfere.
No, Milord, there are other Milord. On the order also, there was interim orders, Milord.
Let their response be filed. Let their
No,
response.
Milord. The order was also stayed in other petition, Milord. Please see the.
Here in this court has stayed any such order.
No, Milord, but similar matters are pending before other high courts also, Milord.
Then we'll hear. Then we'll hear.
Milord,
If the final order is passed, then we are not going to interfere at this thing.
No, Milord. No, Milord. The problem is, Milord, they may proceed for recovery, Milord, if a stay was not
Let
given.
their response may come. Let their response may come. Then only we'll consider. Otherwise, no.
No, Milord, my submission is that, Milord.
Just a minute. Hold down. Yes.
Milord.
No. Should you say from beginning? From beginning. Start second. उससे पहले क्या था? Notice, Mr. So-and-so put an appearance on behalf of so-and-so respondent. Services therefore complete. The counsel for the respondents may file their response within a period of 4 weeks. Full stop. Learned counsel, Mr. Kyle, has submitted that in the other matters where this court has entertained, the final order has not been passed, whereas in this matter, the final order has already been passed. Full stop. It is submitted that in those matters, the court has observed that if the final order may not be passed here, in this case, as the final order has already been passed, such a stay order cannot be granted. Full stop. Taking into consideration the above fact, we are of the view that the therefore interim relief would be considered at after the reply filed on behalf of the respondents. List this matter on so and so. 4 weeks.
Milord, may I request, Milord, till at least next hearing, there will not be any court steps moved.
Yes.
At least till next date of the response, there will not be any court steps, Milord. Otherwise, they may record.
Let the response become, then only we'll consider your interim pay. Yes. Yes.
Item 28.
My pleasure, my lord.
And this is a public interest litigation, my lord, in connection of a road construction. My lord, it was a, my lord, work project, which was, my lord, sanctioned by the government after long agitation of the public. And my lord, even after the expiry of the stipulated period, Nothing was happened, my lord. No construction was executed. Other, my lord, they released a huge fund. On the other hand, my lord, on consideration of the public complaints, some specific orders were issued, even after the expiry of the period of, stipulated, expiry of the
Yes,
stipulated
sir.
period.
What's your instructions?
This is for the first time,
First time, you are in,
I have to take the instruction,
you are in receipt of the copy.
I have received the copy,
At least, once you have received the copy, at least get the factual report from the persons whether the work started or not. What's the problem in that?
Kindly give me.
What's the formality in that? When you have received, you received the copy on what date?
I have been handed over the copy today.
In 9 April.
By way of this PIL, the petitioners have raised a grievance that despite sanctioning of the project, the project, the road, the concerned road has not been, the construction of the concerned road has not been started after a long duration. So issue notice, Mr. Dina put in appearance on behalf of
Respondent number 1 to 5.
1 to 5. Let notice be issued to the respondent number 6, 7, and 8. Return number 1 to 5, and these are the assistant. Why you have made these persons as
Well, a person, because remember, he himself, my lord, involved in the matter, and it is at his instant money was released.
Huh?
My lord, executive engineer. Executive engineer, respondent number 6.
Why you have made them party?
Because he is the man, my lord, he is the instrument who released the entire fund, my lord. Because, my lord, at his instance, my lord, fund was released. He took all initiative to get the fund of the from the government.
You can only be, is a 1 to 5.
If you notice the respondent number 1 to 5 only, Mr. Dinath. In 1 to 5 only at this stage, Mr. Dinath accept notice on behalf of the respondent number 1 to 5. He may file his response. So no need to issue formal notice. He may file his response by the next date of hearing. Put up.
I was interested.
Yes.
Item 31.
Even over is not.
Reading is completed, my lord. So, 25, it has come before this court.
Lordship will fix a non-miscellaneous there because it will take time because the questioning of charge, lordship. The charge has been quashed, lordship.
By the tribunal.
Pleading is also voluminous, lordship.
Somewhere I found that somewhere.
In response to the charge sheet, the inquiry was already concluded.
No, it could not be begin because he moved the tribunal, lordship.
12 years has passed after that. Charge was issued. In the meantime, he got promotion and ACRs are already outstanding, and
so
there is a procedural lapse also, my lord. DOP, they have not followed the DOP circular, DOPT circular, my lordship.
Charge was issued 2018.
So having heard the land concept of the parties, we deem it appropriate to admit the petition, hence admitted no need to issue formal notice as parties are already represented. List for hearing in due course.
My lord, at least date may be fixed because we have
date, hearing date in August, some date in August.
My lord, July if possible, lordship.
Not possible, sir. Yes.
July, my lord, for which date, man? August.
August.
Date, my lord.
Date, whatever you want.
Item 33 and 34.
Another bench. Another bench, circle लिखते हैं.
Item 35.
34, 33, here, man, I'm here.
33 and 34.
Yeah, I'm here.
Not by me.
Not,
Another bench.
my lord, what if there's the execution case pending, my lord?
Yeah.
Execution case is pending, my lord. This fix execution.
Once we are
Yes, my lord.
making an exception, how can we pass an order?
Yes.
We can simply pass that put up before another bench. You may pray before the another bench.
Yeah, please, your lordship. My lord, we have filed the affidavit in reply today. My lord, the matter may be taken up after 1 week.
Now, what relief we can grant you? The problem is what happened in that state level inquiry committee?
My lord, the inquiry committee report, my lord, held that, my lord, she doesn't belong to STP category.
That has been final.
And that has not been put to challenge, my lord. Their inquiry report still stands.
She's talking about certificate complete 5 years ago. And that thereafter the regime that is to be looked into by the SME only can do whatever.
My lord, I am appearing for the committee, my lord.
We are
Here
for the SLC.
SLC, my lord. My lord, what happened?
After passing of this judgment of the learned single judge, the SLC has again looked into the matter.
No, my lord.
Why?
My lord, they have to approach with, during the final course of argument, my lord, they brought in some documents.
Yes.
So that has to be placed, my lord, before the committee, my lord.
So they have not placed that document.
My lord will direct the committee in a time frame. They will look into it and they will pass the final order, my lord.
That the learned single judge is already directed. The direction is already there.
My lord, they have to approach, my lord.
Although we otherwise accept the report, but in view of the production of the general bodos also, the petition is given to the same before the state level scrutiny committee. Whether you have produced that document before the state level scrutiny committee?
Yes, my lord.
Mr. Counsel, the learned single judge has granted liberty to the petitioner
Yes, ma'am.
to approach the state level scrutiny committee with the whatever evidence you have.
Yes.
Yeah, whether you have approached.
Yes, ma'am.
When?
He is not very clear, my lord. He has to take instruction from his senior. My lord will pass a direction, my lord.
Medical admission is gone. So with the validity of the certificate. You can't go back now. That has to be remedied. The only thing is to return from a certificate that is valid. That is valid. It will be looking to that candidate. That is. And also some state level committee, they were doing that inquiry in a very proper way. You cannot accept that. They will go into
The controversy involved in this petition is regarding the validity of the scheduled tribes in bracket plains certificate issued in favor of the appellant. Stop the admission of the appellant in the medical course was cancelled by the respondents on the ground that the certificate, STP certificate issued in her favor was cancelled by the state level scrutiny committee. Stop. The learned single judge has refused to interfere in the matter, taking into consideration that during the course of argument, the appellant has produced the certificate of General Secretary of Bodo Sahitya Sabha dated 29/9/2023, certifying the appellant as an STP has granted liberty to the appellant to produce the said certificate before the state level scrutiny committee, who shall, after considering the case of the claim of the appellant, was required to pass a speaking order to stop learned counsel for the appellant is not in position to apprise this court whether the appellant has approached the state level scrutiny committee along with the said certificate on which she has placed reliance before the learned single judge. Stop. In the facts and circumstances of the case, we deem it appropriate to direct the appellant to approach the state level scrutiny committee along with the certificate of the General Secretary of Bodo Sahitya Sabha dated 29/9/2023 within a period of 2 weeks, from today to stop if the petitioner approaches the state level scrutiny committee, the state level scrutiny, the approaches within the stipulated time, the state level scrutiny committee shall conduct a thorough inquiry and as per the law laid down by the Honorable Supreme Court in Madhuri Patil versus so and so, so and so.
It's 6 Madhuri.
You have the
I have 9/2000.
Madhuri Patil.
Madhuri Patil, I'll give it. What do you?
So and so, and thereafter pass a reasoned order within a period of 2 months thereafter and place the same before this court. Less after 10 weeks.
My lord, Madhuri Patil, 1994, 6 SSC 241.
You supply the details to the court.
My lord.
Item 28.
May it please the Lord. My lord, the petitioners before lawsuit were master role and workers, my lord, appointed.
Please speak loudly.
The petitioners before the lawsuit, my lord, appellants before the lawsuit, my lord, were initially appointed as master role and works as workers.
Master
Role and works as workers, my lord.
casual workers.
My lord,
Okay.
subsequently, their services were regularized by creating personal post by the government. So a cabinet decision.
17/3 GLM.
After a regularization, my lord, they were praying for promotion to the next higher post. Earlier, in the earlier round of litigation, this honorable court, the learned single judge, my lord, directed the authority to consider their cases. Their cases were considered by the authority. They have rejected their claim on the ground that as they were appointed against, regularized against personal post, they are not encadred and they are not entitled to promotion. That is the case of the state.
And the Dilip Talukdar case is already.
Yes, my lord.
So what happened in the Dilip Talukdar?
Dilip Talukdar is annexed, my lord, in the writ appeal.
What happened in the writ appeal?
Yes, ma'am. In the affidavit, they brought that Dilip Talukdar, my lord, and that has been annexed, my lord. That
So what's wrong with the judgment of the judge?
the lawsuit will find at base 113.
And here the respondent will say, we being the regular, he was in the regular, he has been given. One category. No ever.
Manoj, before going to Dilip Talukdar, if I'm permitted, Manoj, I would like to draw your lordship's attention page 42.
we are disputing that your posts were encadred posts.
Yes, my lord.
Not this personal post.
Personal post, it is personal post, but they were, my lord, regularized against, my lord, grade 4 post. Grade 4 cadre, in the grade 4 cadre, in the regulation
Show us,
order itself, my
Show
lord.
us, show us.
My lord, page 42, my lord.
Page 42,
My lord. This is the regulation order, my lord.
42.
My lord.
Read.
In pursuance of government order number so and so, as well as finance department conference number so and so, the services of the following master laborers under Silchar Rural Roads Division are hereby regularized in the scale of so and so, along with other allowances as admissible as per rules, with effect from 22/7/2005 by newly created personal post as grade 4 cadre.
So, next, further
The
line.
posts are personal to the incumbent concerned and will be abolished on relinquishing the services concerned incumbent in any manner.
What remains?
Madam, that can be relinquished even after promotion also, madam. After promotion.
That can't be done. That can be done. Yes.
Now, Lordship turn to page 113, that is the decision of Dilip Talukdar, my lord.
Page number?
Page number 113, my lord.
130.
My lord.
This is the judgment.
Yes.
Paragraph 8 at 114, my lord.
Paragraph?
8 at 114, my lord. Page 114, my lord.
Yes.
The court analyzed the concept of personal post noted on the regulation of services of so and so were not against any cadre post of the department, but the post so created also to be treated as ex-cadre post. So, my lord, that Dilip Talukdar case was decided on the basis that those persons were not encadred. But
Next para, read next para.
yes, my lord. As promotion to higher rank can be considered only from the feeder cadre, and since the petitioners were not encadred in the feeder cadre, the learned single judge opined that they were disentitled to claim promotion to the higher cadre.
Para 12 also.
But in my regulation order, Lordship has seen that we have been encadred.
No, not encadred. This is simply said that it is
Grateful vacant.
against that personal post, and the post will be abolished at the time of your superannuation. That is very much clear.
That is true. That is true, my lord. That is true.
Something else?
My lord, considering the Dilip Talukdar case, my lord, this honorable court, my lord, on another occasion, my lord, asked my learned senior, my lord, friend from the government side, my lord, that whether SCP was granted to the appellants or not.
SCP?
SCP, my lord, assured career progression.
If
That
that
has,
rules permits that, then certainly it would be granted.
well,
not
SCP, they are entitled to the SCP, my lord. They are entitled to the SCP.
Yes.
And they have said that SCP has been granted.
To that effect, we have filed the affidavit, my lord, bringing on record that that has been given.
That would be given.
Yes, that has been given, and we have filed the affidavit to that.
If there is any,
On 7 to 2024.
some area benefits are yet to be paid. So that
You are saying the landed single judge order, if the idiots are not given or anything else, not that is a separate cause of action, you approach the.
My prayer would be, my lord, Lordship will close the writ appeal, my lord, directing the authority, my lord, if any area dues are there, my lord, that can be released to the applicants.
That is actually not
can't,
connected with this, my lord. On
the scope of.
no, not within the scope, my lord. When the matter was moved, my lord.
Even prayer before the learned single judge, how can we grant this relief to you?
On that writ appeal, my lord. Lordship will
Writ
remove the
appeal
prayer, my
is
lord.
not we can't enlarge the scope of the writ appeal by giving directions which are neither here nor there. Can't be done. We take the order.
As your lordship, please. Oblige, my lord.
Item 39.
Lordship, the short question involved is Lordship, whether the OM by which the tenure posting has been fixed in the northeastern region, that can be fixed to a member of the DRDO in the Defense Research and Development Organization, Lordship. Yes, V250 that under the rule, Lordship, allocation of business rule, that will Lordship will find at page 150. And the relevant portion is at 155. That the DRDO and certain department has been kept out of the purview of the DOPT, Lordship. That is Public Grievance Administrative Reforms. Certain Lordship find that service conditions serial number 4, 21 and 22.
150.
155, Lordship.
Yes,
Serial number 21 and 22, Lordship.
yes.
General questions, then conditions of service of central government employees. That and DRDO has been kept out of that purview, Lordship. So our contents is that since it's a research organization wherein the person can be, and moreover, he has been involved with 2 projects, Lordship.
Excluding the control of Department of Railways, Atomic Energy, Department of Electronics and Department of Space and Scientific and Tribunal, Technical Personnel and Department of Defense
And
Research and Development, other than those financial bearing on the front.
These are the organization has been kept out of the purview of normal, whatever the service can laid down by the DOPT, Lordship. Now, Lordship will find at page 159, he has been involved with 2 projects. And this willingness has been submitted in 2022. In one of the project, he is involved with the Tezpur University. So if he moved out of the Tezpur, Lordship, certainly this project will, Lordship find a serial number 8 and 9 at page 159. These are the 2 projects which the respondent is involved, Lordship. And in one of the projects, he is involved along with the Tezpur University, Lordship. And moreover, Lordship, we have a station seniority list at page 160. There are person even from 2003, 2007, 2008. So these are the difficulties, Lordship, in releasing him. He came to Tezpur at his own request. Of course, he is here in from 2014, Lordship.
2014.
2014. Being a scientific organization, Lordship, if anybody is allowed to move out.
Clear. 153 earlier. The latest order is
Initially, the OA was allowed, then we moved this code.
this was put up on the we represented 132. Yes. Remand order. After remand. 133. This by this. Pressure. That cannot be the detail of it. Always made really find that this man is the office political. He is great by the time. This man is from people from money. But you see,
So, we'll post this when out of this northeast region after completion of that project, or you will not post him at any point of time.
My lord, if I may,
Please.
not.
Right now, don't have the instruction, but Lordship may clarify that position.
Define that position, yeah, but up to what time you'll retain retain this person
With this
in the
process.
northeast region? There must
Till
be
how
some
long?
limit.
Till how long, Lordship?
Till how long? Yes.
Till how long? No sooner the,
You may be justified in saying that since the projects are going on and will not be able to spare him on the due to non-availability of suitable
Similar.
persons in place of him. But up to what time?
Lordship, for that, Lordship,
You can't retain him for
Lordship,
the
indefinite
whole
period.
service tenure.
Lordship.
There must be some. Normally, the person with the DRDO project can't be transferred frequently or whatever it may be, you can say. But up to what time you will consider it plus?
I have to, for that, I have to take instruction till, at what stage it is?
You have to find out a way. Usually, here, the man is continuing here. That's why he's interested.
You are referring to the persons who are working since 2003. That person is of the same region, so he is having his own interest.
There are other also, there are others from the outside.
Yes, also, they may be settled here or whatever for reasons they are not asking for their transfer. But that doesn't mean how long you will continue.
Lordship, for that, will take limited instruction to that regard, Lordship. We fix it on Wednesday.
Ultimately, he is not comfortable here and he is asking for 4 places. What remain?
Okay.
Maybe legally you are right that he can't be transferred as a matter of right, but ultimately you have to consider it.
Lot.
Okay. And in concept of the petitioner, place some time to apprise this court that how long the respondent respondents, how long the
sole respondent, Lordship.
how long the petitioners are willing to continue the petitioner, they continue the respondent to work on the present place of posting. And consent may supply, they may apprise this court by the, on the next date of hearing about the above noted fact. List on
Thursday, Lordship. Thursday.
Thursday.
No problem.
Problem.
At least you make up your mind.
Lordship.
My lord, now the order has been passed, my lord. They are saying that he has been engaged in some project, my lord. That project has been given to him in 2022. Right now, my lord, at present, he is not involved in any project, my lord. It's my instruction, my lord. Let them bring, my lord. So that is the only.
Lordship. Adjust in somewhere else.
Yes, my lord. Deeply obliged.
Item 40.
May it please your lordship. Well, in this case, the respondent bank has filed an affidavit in opposition. We want to file a rejoinder to that affidavit. 1 week time.
Lordship, otherwise, Lordship, the issue which they have raised, in fact, the entire writ petition was filed obstructively to stall our surface action. There are only contentions. Lordship, writ petition was filed to stall our action under the surface act.
Auction.
Yes, Lordship.
That they're successful in that.
Yes, Lordship. And the second contention, Lordship, they have raised a point of law, Lordship, whether bank can proceed simultaneously under both the Surface Act and the DRT Act. That is recovered. That has already been settled by the Honorable Apex Court. Nothing left.
That is true, but the action, lordship, kindly see on 1/4 we have in the affidavit page 98.
Yes.
And they have rejected our last proposal.
What's the business this court is having that no, go and have another settlement?
No, we are going to, we are opposing the bank for settlement, but every time they are rejected. This is the fourth time they have rejected our
Have you
offer.
gone through the latest judgment of the Supreme Court?
Hello, 1 week time, my lord, we file a rejoinder.
Just tell me.
Man, I have
you
gone
gone
through.
The
I-
10th of April only.
My lord.
That the Supreme
April, I
Court
have
has
not-
again deprecated this practice. Don't interfere in these matters.
This United Bank of India.
My lord, I need only 1 week time, my lord, to file a rejoinder.
Latest time. April.
10th April.
I missed them.
2 days.
No, I got it. Yes, answer. Yes.
That is there.
No, it's not. What more?
Well, I'll go through that, my lord, only some time, my lord.
You have gone through this.
No, I have not gone through it. That is,
Supply him the copy.
my lord, next week, any date, my lord.
Next week. Come, go through this order and come. Nothing, sir. You have to approach.
No, at least,
Yes,
my lord,
we-
at least an opportunity be provided to file a rejoinder to that affidavit, my lord. They're acting in a malafide manner, my lord.
Lordship, their dues is 21 crores and they are offering an OTS proposal of only 2 crore. Can it be possible?
No. Already we have,
Best
we have, my lord, we have paid 9 crore
On the
out
last
of,
occasion, why we have interfered while taking into consideration this fact that he offered, he given a offer
Lordship,
and you communicated with him, give us a better offer.
Lordship.
And in the meantime, you initiated the process. That's why only we interfered.
Lordship, I got it.
How you are justifying that?
Lordship, because he can make an proposal for OTS, Lordship, we cannot stop him. But Lordship, when a proposal of OTS is being accepted, Lordship, one of the ingredients that he have to make the payment, Lordship, as per the schedule of the OTS proposal. That he failed in the year 2018 itself.
Earlier, he applied for OTS.
Yes,
Yes.
OTS, Lordship.
that was considered, my lord, out of 10 crore, my lord, we have paid 9 crore, my lord.
That's good.
Thereafter, my lord, due to my lord, COVID pandemic, my lord, we could not pay company. So in June, my lord, we are getting,
Aggrieved by whatever the action, you
My
approach
lord.
the DRT.
My lord, till June, we
and-
need,
And if DRT, any order is agreed by the DRT, go to the appellate tribunal. That's very
my lord,
clear.
my lord, our problem is in June, my lord, we are getting funds. So within June, my lord, we will clear.
We are not supposed to, that is for the bank to consider. If the bank is ready to accept your offer, if they may prolong the matter up to 2 years or 5 years or whatever.
And that is true, my lord. So, my lord, 1 week time, my lord, file a rejoinder, my lord.
Well, there is no
Only-
question of.
only
filing
1
of
week, my lord.
rejoinder.
Yeah, I think they are approaching us at recovery certificate, I think.
This is what we should. Sir, we are sorry.
Hmm.
Yes. You want an order on merit or you want to withdraw this with liberty to approach the appropriate forum under the SARFAESI Act?
My lord, under the sufficiency approval, till then, my lord, my lord,
No, not at all. This is not the best. We are not entertaining, you are withdrawing.
if written
That is-
petition is dismissed, my lord, they will immediately, by tomorrow, they will.
Yes, they,
So at least,
they-
till the filing or,
they are entitled for that under the law. We are not interfering. in
my lord,
that.
we will file within 7
After-
days.
After this judgment of the Supreme Court, please, sorry.
So, my lord, at least 7 days, my lord, protection, my lord, we'll file.
Sir, there is no question. The Supreme Court has deprecated this practice. Why you high courts are interfering in these matters? This is a reportable judgment, sir. Look here. After attempting to argue the matter for quite some time, learned counsel for the petitioner on instructions has submitted that he wants to withdraw this writ petition. However, seeks liberty for the petitioner to avail appropriate remedy available to him available to it under the surface Act, dismissed with liberty as prayed for.
But till then, my lord, only 1 week time, my lord.
Again, this is
Otherwise, my lord.
fourth time we are praying and we are refusing, sir, please.
Password meter 18.
I can keep a copy. I think it was, no, it was given. I brought a wrong judgment. Both were kept together. I picked up the other ones. So that's why, but I'm keeping it, sir.
Item number?
Sir, 18.
18.
That certificate one. इसमें है नहीं। That thing is that this is before we take them. Last time. Merit में करेंगे तो they will go through. And it's not fun. Difference not people if they come back. Termination has also been after the order. Page 100. No state. No state.
It is noticed that then the matter is called twice, but none has appeared on behalf of the appellant. It was stopped earlier on 9/2/2024 also. No one has appeared on behalf of the appellant. Stop. It seems that the appellant has lost his interest in the writ appeal. Hence, this writ appeal is dismissed in default for non-prosecution.
Earlier,
Same thing.
appeal was my lord dismissed for non-prosecution.
Non-prosecution.
It was restored then.
That's right.
Matter.
Oh, yeah.
For pronouncement of judgment, item 1 to 3.
Appeals dismissed.
Item number 4.
We don't find any case for interference, appeal dismissed.